shall invite my Lord Justice Nugee, to give the first judgment.
This appeal from the Upper Tribunal Lands Chamber concerns the question whether a lessee has to contribute by way of service charge to the costs incurred by its lessor on repairing the roofs of two properties in Plymouth. The appeal concerns two flats in Rothsay Gardens, numbers 96 and 146. They are in separate buildings. In each case, the freehold is now owned by the appellant, a registered social landlord called Plymouth Community Homes Ltd, who I will refer to as the lessor. Each is let on a long lease, originally granted in 1990 by Plymouth City Council to individuals, pursuant to the right to buy legislation in the Housing Act 1985. Each lease is now held by the respondent, Crisplane Ltd, who I will call the lessee. In 2018, the lessor inspected the roofs of the two buildings and found them to be at or close to the end of their useful life. The roofs were repaired. There is no dispute that the costs incurred were reasonable. The question is whether the lessee has to contribute to them under the terms of each lease. Although the question is the same with each flat, the arguments are not, and they have to be looked at separately. Proceedings were started in the County Court, but the question of liability for the service charge was transferred to the First-Tier Tribunal. The First-Tier Tribunal, Judge Tilsley, Judge A. Cresswell and Mr. R. Brown, decided in a decision handed down on the 12th of April 2023 that the lessee was liable to contribute to the cost of repairs, its liability being quantified at £7,965.60 in respect of each flat. The lessee appealed to the Upper Tribunal. The appeal was heard by the Deputy Chamber President, Mr. Martin Roger Casey, in a decision dated the 16th of January 2024, publicly available at 2024 UK UT 15 LC, he allowed the lessee's appeal. The lessor now appeals to this court with the permission of Lord Justice Snowden on two grounds. Ground 1 only applies to number 96 Rothsay Gardens, and ground 2 only applies to number 146. We have this morning heard interesting and well-argued submissions from Mr. Jonathan Ward on behalf of the appellant lessor and from Mr. Rawdon Crozier on behalf of the respondent lessee. I prefer those of Mr. Crozier and would dismiss the appeal. In short, I completely agree with the analysis so lucidly and cogently set out by the Deputy President in his decision, which seems to me entirely correct in all respects. Indeed, I could, I believe, stop this judgment here, as I do not really need to say any more than that. But in deference to Mr. Ward's argument, I will say a little more to explain why I take that view. I will start with ground 1, which concerns number 96. The lease now held by the lessee was granted on the 26th of February 1990 by Plymouth City Council to a Mr. and Mrs. Whitehead for a term of 125 years expiring on the 25th of February 2115. It is common ground that it was granted under the right to buy legislation, and this is reflected in clause 2, which refers to the lessor acting pursuant to the provisions of section 122 of the Housing Act 1985. Number 96 is described in the lease as the upper flat, and I can take a description of it from the decision of the Deputy President as follows. Paragraph 13, he said, each of the flats is in a separate building. Each of the buildings is a 2-storey Cornish unit containing 4 flats, 2 on the ground floor and 2 on the upper floor, each with its own separate entrance. The buildings were constructed in the immediate post-war period, either in the late 1940s or early 1950s. Then at paragraph 19, he says, the property is defined as the building shown on a plan annexed to the lease. Notwithstanding that description, it can be seen from the plan that the property is only half of the building divided vertically and comprising number 94 on the ground floor and number 96 on the upper floor. The property does not include the other half of the building comprising numbers 98 and 100. And at paragraph 20, the demise premises means number 96 consisting of the upper story of the property, including the floor, half of the depth of the joist supporting the floor, the roof, and the rainwater gutters of the property, as well as front and rear gardens. Clause 3 of the lease contains a covenant by the lessee as follows. The lessee hereby covenants with the lessor that the lessee will observe and perform the obligations on the part of the lessee set out in the 3rd schedule here too. I will come back below to the relevant part of the 3rd schedule. Clause 4 contains a corresponding covenant by the lessor in the following terms. The lessor hereby covenants with the lessee that subject to and upon the condition expressed in clause 12 of the 3rd schedule hereto, it will observe and perform the obligations on its part set out in the 4th schedule hereto. If one goes to the 4th schedule, one sees a number of covenants by the lessor. For present purposes, the relevant ones are clauses 4 and 5, which read respectively as follows. 4. The lessor shall keep the reserved premises and all fixtures, fittings and apparatus therein, and additions thereto in a good and tenantable state of repair, decoration and condition, and that has to be read with the definition of reserved premises, which in effect means the ground floor flat, meaning the lower flat known as 94 Rothsay Gardens. Paragraph 5 of the 4th schedule reads, the lessor shall keep and maintain the exterior of the property, excluding the roof thereof, in good and tenantable repair, decoration and condition. And then there's a proviso which I need not read. Reverting to the lessee's covenants in Schedule 3, the only relevant one is that in paragraph 12, which reads as follows. The lessee shall contribute and shall keep the lessor indemnified from and against 1/2 of all costs and expenses incurred by the lessor in carrying out its obligations under and giving effect to the provisions of the 4th schedule hereto, including clauses 8 and 9 of that schedule, but excluding clause 4 of the said schedule, and in enabling the lessee to enjoy the rights contained in the 1st schedule hereto. As a matter of construction of the lease, this seems to me entirely clear. The lessor covenants to repair the exterior of the property, but not the roof. The lessee covenants to pay 1/2 of the costs incurred by the lessor in carrying out these obligations. It is evident that as a matter of construction, the lessee is not obliged to contribute to the cost of the repairs to the roof. As the Deputy President put it in his decision at paragraph 51, at number 96, the 4th schedule imposes no obligation on the lessor to carry out any work to the roof at all. The roof is not part of the reserved premises and therefore does not fall within paragraph 4. The obligation in paragraph 5 to keep the exterior of the property in repair is subject to the express exclusion of the roof. On the face of it, therefore, the 4th schedule imposes no obligation to repair the roof, and it follows that paragraph 12 of the 3rd schedule does not require the lessee to contribute towards the costs of any work which the lessor carries out to the roof. At this point, however, one must refer to the provisions of the Housing Act 1985, under which the lease was granted. Section 139(1) of the Act, headed Terms and Effect of Conveyance or Grant a Mortgage, reads as follows: a conveyance of the freehold executed in pursuance of the right to buy shall conform with Parts 1 and 2 of Schedule 6. A grant of a lease so executed shall conform with Parts 1 and 3 of that schedule, and Part 4 of that schedule has effect in relation to certain charges. When one goes to Schedule 6 to the Act, it contains a number of provisions, those in Part 1 headed Common Provisions, dealing with both grants of the freehold and grants of leases, and those in Part 3 dealing with leases. For present purposes, the relevant paragraph is paragraph 14, headed Covenants by the Landlord, and it reads as follows: 14.1. This paragraph applies whether dwelling house is a flat. 2. There are implied covenants by the landlord, A, to keep in repair the structure and exterior of a dwelling house and of the building in which it is situated, including drains, gutters and external pipes, and to make good any defect affecting that structure. And then I need not read 2b or c or 3 or 3a, but 4 reads: the County Court may, by order made with the consent of the parties, authorise the inclusion in the lease or in an agreement collateral to it of provisions excluding or modifying the obligations of a landlord under the covenants implied by this paragraph, if it appears to the court that it is reasonable to do so. It is not disputed, but in the present case no County Court order was made under paragraph 14.4, but that means that the lessor is under an implied covenant to repair the structure and exterior of the dwelling house and of the building in which it is situated. It is also not disputed that the roof is part of that structure and exterior. Hence it is common ground that the lessor was obliged to repair the roof over number 96. The question is whether the lessee was obliged to contribute to the cost of it. Paragraph 16a of Schedule 6 provides as follows: 1. The lease may require the tenant to bear a reasonable part of the costs incurred by the landlord, A, in discharging or insuring against the obligations imposed by the covenants implied by virtue of paragraph 14.2, repairs, making good structural defects, provision of services, etc. Or, and then I need not read the rest of that paragraph, but I should refer to paragraph 16a(4), which reads: where in any case the obligations imposed by the covenants implied by virtue of paragraph 14.2 or 3 are modified in accordance with paragraph 14.4, power of County Court to authorise modification. The references in this paragraph are to the obligations so modified. The provisions of paragraph 16a are, as Mr. Ward accepted, permissive provisions. The statute does not itself impose any obligation on tenants to pay service charges and does not require a lease granted under the Act to include any service charge provision at all. In a decision of this court called the Mayor and Commonalty and Citizens of the City of London and various leaseholders of Great Arthur House, 2021 EWCA Civ 431, Lord Justice Lewison said at 38, that may well mean that the cost of some works that are within the landlord's obligation to make good structural defects cannot be passed on to the lessees, but that is a consequence of the way in which the definition is drafted, and there is no presumption that the cost of all works that the landlord is obliged to carry out can be passed on to the lessees. Campbell and Dejan Properties Limited, 2012 EWCA Civ 1503, 2013 1 PNCR 14 at 56. On the face of it, therefore, the position is very simple. Again, I agree with the way in which the Deputy President put it in his decision. At paragraph 53, he said this: the FTT was clearly correct that the effect of paragraph 14.2 was to subject the lessor to the implied covenant to keep the whole of the structure and exterior of the flat and the building in which it was situated in repair. ... At number 96, the implied covenant is the only obligation on the lessor to repair the roof. 54. But the covenant implied into the lease by the statute says nothing about any corresponding obligation on the lessee to contribute towards the costs incurred by the lessor in complying with it. Moreover, paragraph 16a(1) of Schedule 6 leaves the parties free to agree whatever terms they choose about contributions by the tenant towards costs incurred by the landlord in discharging the implied obligations, provided those contributions do not exceed a reasonable part of those costs. In neither of these leases did they expressly agree anything about those costs, nor can any obligation to contribute be applied. ... At number 96, the lease works perfectly well, the only relevant obligation being the lessor's implied covenant to keep the structure of the building in repair without the need to imply any corresponding payment obligation on the lessee's part. It cannot be said that the absence of a service charge covering the implied obligation causes the lease to lack business efficacy, and then he refers to the passage I've already referred to from the judgment of Lord Justice Lewison in Great Arthur House. I entirely agree. Or if I can put it in my own words, here the lessee expressly agreed to pay 50% of certain costs. Those were the costs specified in Schedule 3, namely complying with the lessor's obligations in Schedule 4. That did not include any repairs to the roof, so the lessee never expressly agreed to contribute to the cost of roof repairs, nor does the statute impose any obligation on the lessee to do so. It does impose a repairing obligation on the lessor, but not a corresponding payment obligation on the lessee. It is up to the parties to decide if such a payment obligation should be imposed. That depends upon the terms of the lease. Under the terms of this lease, they did not do so. What then is Mr. Ward's argument to the contrary? He fastens on paragraph 14.4 of Schedule 6. He says that provides that the parties can modify the implied covenants, but that requires an order of the County Court. Hence, he says, the words in paragraph 5 of Schedule 4, excluding the roof thereof, are an attempt by the parties to modify the implied covenant. But no County Court order was obtained, so those words are ineffective. Paragraph 5 should therefore be read as if they were not there. Read like that, the lessor's obligations under paragraph 5 of Schedule 4 includes an unqualified obligation to repair the exterior of the property, hence the obligation of the lessee to contribute is to contribute half of the costs of complying with that unmodified obligation. This is an ingenious argument that Mr. Ward advanced tenaciously, but I do not accept it. I prefer the view that the only express obligation of the lessor to repair is that set out expressly in paragraph 5 of Schedule 4. This is admittedly less extensive than the covenant implied by statute. In fact, in two respects, because not only does it expressly exclude the roof, but it also only expressly extends to the exterior of the property and not the structure of the property, which may be different. But I do not see why it should not mean what it says. The effect of limiting the landlord's express covenant in this way is to limit the lessee's payment obligation. Correspondingly, the payment obligation being tied to the landlord's express obligations under Schedule 4. So although the wording in paragraph 5 may be ineffective to exclude the landlord's implied repairing obligations under the covenants implied by paragraph 14 of Schedule 6 of the Act, I see no reason why those words are not effective to confine the lessee's payment obligation to what he has expressly agreed to contribute towards, and that does not include, indeed expressly excludes, the roof. Again, I can refer to the way in which it was put by the Deputy President. In his decision at paragraph 56, he says this: I do accept that the parties were not free to contract out of a statutory implied covenant, but that does not require any rewriting of paragraph 5. Paragraph 14.4 of Schedule 6 restricts the extent to which the parties may exclude or modify the obligations of a landlord under the covenants implied by paragraph 14. It has no effect on their express covenants, whether or not they are inconsistent with paragraph 14. The implied covenant to repair the structure and exterior of the dwelling and of the building is an additional obligation, the meaning of which is clear and which applies unamended. So far as it goes, the express obligation in paragraph 5 of the fourth schedule duplicates, but is not inconsistent with the implied obligation. In both leases, the lessor is obliged by the statutory implied covenant to repair the roof, notwithstanding the exclusion of the roof from a separate covenant at paragraph 5 of the fourth schedule, 57. But for the reasons I've already given in paragraphs 54 and 56 above, I do not accept the implied covenant requires that the leases be read as if the words excluding the roof thereof did not appear in paragraph 5 of the fourth schedule. 58. It follows that when the respondent replaced the roof of number 96, it was not carrying out any obligation under the fourth schedule. It was complying with the implied covenant. Again, I entirely agree. For those reasons, I think the Deputy President came to the right conclusion in the Upper Tribunal, and I would dismiss ground 1 of the appeal. Ground 2 of the appeal concerns number 146. Here, the lease was granted on the 25th of June 1990, again for a term of 125 years, in this case expiring on the 24th of June 2115. It was granted by the City Council to a Mr. Midgley, again pursuant to the provisions of Section 122 of the Housing Act 1985, that is, under the right to buy legislation. The demised premises are defined as meaning the lower flat, known as 146 Rothsay Gardens, and the reserved premises means the upper flat, known as 148 Rothsay Gardens, and expressly includes the roof of the property. The other provisions of the lease are very similar to those in the lease of number 96. Thus, so far as the lessor's covenants are concerned, clause 4 contains a covenant by the lessor to observe and perform the obligations set out in the fourth schedule, and the fourth schedule in paragraph 4 contains an obligation to keep the reserved premises, etc., in repair, and clause 5 contains an obligation to keep the exterior of the property, excluding the roof thereof, in repair. So far as the lessee's covenants are concerned, clause 3 again contains a covenant by the lessee to observe and perform the obligations of the third schedule, and paragraph 12 contains an obligation to contribute half of the costs, quotes, in carrying out its, that's the lessor's, obligations under and giving effect to the provisions of the fourth schedule here to including clauses 8 and 9 of that schedule, but excluding clause 4 of said schedule, and in enabling the lessee to enjoy the rights contained in the first schedule, here too. I will come back to the final words on which this ground is based, but before getting to that, the express exclusion of clause 4 of Schedule 4 from the lessee's service charge obligation in paragraph 12 of Schedule 3 means that it was expressly agreed that the lessee was not liable to contribute to the costs of keeping 148, the upper flat, in repair, those being the reserved premises. And since the reserved premises include the roof, there was an express agreement in paragraph 12 of the third schedule that the lessee was not liable to contribute to the cost of repairing the roof. That's what the Deputy President said in the Upper Tribunal at paragraph 48 as follows. It follows that having regard only to the express terms of a lease of number 146, the lessee has no obligation to contribute towards the costs incurred by the lessor in carrying out repairs to the roof, because the roof is specifically excluded from the parts of the property covered by paragraph 5 of the fourth schedule, and the lessee's obligation in paragraph 12 of the third schedule does not include contributing to costs incurred in complying with paragraph 4 of the fourth schedule, which does extend to the roof. That seems to me to be clearly right, and it has not been appealed. But as I read, paragraph 12 also includes at the end the words costs incurred by the lessor, quotes, in enabling the lessee to enjoy the rights contained in the first schedule here too. The first schedule contains a grant of various rights to the lessee together with the demise. They include, for example, rights of way, rights of passage of media services, gas, electricity and the like in the familiar way. Paragraph 3 of the first schedule reads, 3. All rights of way, support and other easements and all quasi-easements, rights and benefits of a similar nature, now enjoyed or intended to be enjoyed by the demised premises over any part of the premises and the estate. I should also note paragraph 5, repairing, maintaining, renewing, altering or rebuilding the demised premises or any part of the property, giving subjacent or lateral support, shelter or protection to the demised premises, etc. The argument put forward by Mr. Ward is that the wording at the end of paragraph 12 of the third schedule is wide enough to catch the lessor's expenditure on the roof, because one of the rights in the paragraph 3 of the first schedule is a right of shelter for flat 146, the lower flat, from the upper flat, including the roof. In the Upper Tribunal, the Deputy President assumed that that might be so. He said at paragraph 61, as for number 146, I will assume that paragraph 3 of the first schedule entitles the ground floor flat to receive shelter from the first floor flat and the roof over it. I will make the same assumption. I think that it is well arguable that a right of shelter comes within the words other easements and all quasi-easements, rights and benefits of a similar nature, that is similar to the right of support, which is expressly mentioned. But it is helpful to remind oneself of the nature of such rights. Gale on Easements, 22nd edition, 2025, says this about rights of support, at paragraph 10-30. The nature of the right of support for buildings by buildings has been summarised as follows by Sir Wilfrid Green, Master of the Rolls, in Bond and Nottingham Corporation, 1940, Chancery 429 at 438. The owner of the servient tenement is under no obligation to repair that part of his building which provides support for his neighbour. He can let it fall into decay. If it does so and support is removed, the owner of the dominant tenement has no cause for complaint. On the other hand, the owner of a dominant tenement is not bound to sit by and watch the gradual deterioration of the support constituted by his neighbour's building. He is entitled to enter and take the necessary steps to ensure that the support continues by effecting repairs and so forth to the part of the building which gives the support. But what the owner of the servient tenement is not entitled to do is, by an act of his own, to remove the support without providing an equivalent. There is the qualification upon his ownership of his own building that he is bound to deal with it and can only deal with it subject to the rights in it which are vested in his neighbour. If there is a right of shelter granted by paragraph 3 of the first schedule, I think it must be of the same character as Sir Wilfrid Green explains the right of support to be, namely that it is and imposes purely negative obligations on the owner of the part of the building which provides the shelter. Translated to the present case, it means that Plymouth Community Homes Limited, as lessor, could not actively remove the roof and leave the property exposed to the elements. But on the other hand, the lessee had no right under this part of the lease to require the lessor to spend any money on doing repairs, although it could, if it chose, do repairs itself. In those circumstances, I again agree with the Deputy President in the Upper Tribunal. This is for two reasons. The first is that where the roof is specifically and expressly excluded from the service charge obligations by the earlier part of paragraph 12 of the third schedule, it would be contrary to usual principles of construction to hold that an obligation to contribute was nevertheless brought in by the much more general words at the end, the way in which the Deputy President put it in his decision 61, after referring to the assumption that paragraph 3 of the first schedule did confer a right of shelter, was this: on that assumption, I nevertheless find it impossible to accept that the parties intended the cost of maintaining the roof and the structure of the upper flat thereby to become part of a lessee's liability under paragraph 12 of the third schedule. They had crafted paragraph 12 to create a liability to contribute towards the cost of repairing the whole of the exterior of the property except the roof. It seems probable that the purpose of distinguishing between the reserved premises and the remainder of the exterior of the building was specifically to exempt the lessee from a liability to pay for repairs to the roof. But whether that was their intention or not, the parties specifically excluded the roof from the lessee's service charge liability in the third and fourth schedules. It is impossible to believe that at the same time they intended, by their obscure reference to the costs of enabling the lessee to enjoy the rights contained in the first schedule, thereby to make the lessee liable for half the cost of repairs to the roof. Had that been their intention, it could have been achieved by simply omitting the words, excluding the roof thereof, from paragraph 4 of the fourth schedule. I agree, and that is sufficient to dismiss this ground of appeal. But I think it very doubtful in any event if money spent by the landlord on repairing the roof could properly be described as costs incurred in enabling the lessee to enjoy the right of shelter. That is not why the landlord spent the money. It did so because it was obliged to repair the roof by the implied repairing covenants in paragraph 14.2 of Schedule 6 of the Act, not because the lessor desired to enable the lessee to enjoy a right of shelter, which, as I have pointed out, did not by itself oblige the lessor to spend any money at all. Even though, of course, by repairing the roof, it may have had the effect of enabling the lessee to obtain shelter from the roof. Again, I agree with the way in which the Deputy President put it in his decision in this case at paragraph 62. The rights included in the first schedule also included at paragraph 5 an express right for the lessee to repair, renew or rebuild the demised premises or any part of the property giving shelter or protection to the demised premises, presumably at his own expense. In view of that entitlement and the express exclusion of the cost of repairs to the roof from the liability otherwise described in paragraph 12 of the third schedule, I do not read the reference in paragraph 12 to the costs of, quotes, enabling, close quotes, the lessee to enjoy the rights contained in the first schedule as covering the cost of repairs to building components for which liability had already been assigned and excluded. I would therefore dismiss ground 2 of the appeal and with it the appeal.
Thank you very much.
I agree.
I also agree. The appeal accordingly fails and is dismissed. Mr. Ward, Mr. Crozier, any consequential matters or applications we need to address?
There's a cost schedule which was served yesterday, which I hope the court has. It's not in the bundle.
Yes, well, certainly I have it. Do you have a copy? I know that my Lord Justice Stuart-Smith does. I think I received it possibly even this morning, so it's a very recent document.
My Lord, it is.
Cost schedule respondent.
Yes.
Grand total?
The grand total at the bottom is, forgive me, £568.80, inclusive of that.
Are you not able to recover that?
Ooh, I don't know. It's not VAT registered, I'm told. So
Thank you.
I'm grateful. I should have preempted that. It comes up often enough. I do apologise, my lord.
I think, don't we technically need a certificate from solicitor? Can we take that confirmation from your solicitor as in lieu of a certificate?
I see. It's not. I think it. Yes, I've only got printed. It's not. It's not formally signed.
Yeah, the only way of doing it electronically.
Oh, so it's been done electronically. It's intended to stand as an electronic signature, I think, of my instructions.
I can read it.
But I can certainly undertake to file a signed version.
But I haven't looked at it for a little while, but the provision is that if someone is not entitled to is not VAT registered, then I think there's a provision in the rules which says that should be certified by a solicitor.
I do apologise, my lord. I was thinking about whether there was a manuscript signature on the cost schedule.
If my lords agree, we can take that as done, given that your solicitor is here.
I can confirm.
I'm grateful if your lordships would. As I say, I can. If you require the certificate.
We also have a schedule from the appellant, and the difference between them is to be found in the fact of your counsel's fees are higher, reflecting the fact you're more senior. And as I read it, the appellant's schedule does not include for attendance today. So that if one is engaging in a comparison, that
I'm grateful. I didn't think seen the London.
Well, there is a further point of distinction, and speaking for myself, I'd like your help with this. All the solicitors' work has been costed at grade A rates. have to say I wonder why all of it required a grade A fee earner.
I infer, and I will look behind me in one moment to see if it's right, that having conducted the First-Tier Tribunal hearing himself, my instructing solicitor was therefore au fait with the matter, and there would have been additional time at a lower rate in someone else picking up, as it were, getting up to speed. Yes, I'm getting a.
Well, we'll consider that, but we better hear from Mr. Ward.
Indeed.
Mr. Ward.
My Lords, I'm very grateful. My Lord, on the cost schedule from the respondent, which we too only received in late course yesterday afternoon, my Lord, the first observation I was going to make was exactly that a good deal of work has been undertaken by a grade A fee earner. With due respect to the respondent is the respondent in this matter, not the appellant. The heavy lifting has been done by the appellant and the solicitors for the appellant, a good deal of which, if not most of which, has been done by a grade C fee earner. In any event, whose hourly rate is within the national guidelines. I believe that the hourly rate claimed by the respondent is outside national guideline rates.
Do you know what the guideline rates are? It's
Just
not a figure I carry in my head.
No.
Same.
Indeed. If you'll bear with me just a moment, my lord, I'm sorry.
Right.
Sorry. I'm told 271.
271,
behind me.
Very precise figure. Dauntingly precise figure.
Lord, yes.
90%.
Where are your solicitors based?
Plymouth, my lord.
My lords, it's difficult to see why there's been quite so much in the way of correspondence and attendances in this matter. This is not really the conduct of litigation. This is an appeal.
Yes.
Grounds of appeal were provided, a skeleton argument was provided. What was warranted was in fact the work that appears on the documents, which is the respondent's notice, and of course the respondent's skeleton argument, which was drafted by counsel. My lords, I'm not certain if any of this appears in this statement of costs, but of course some work was done by the respondent in an application for relief from sanctions. But
Yes.
if that's not included, then I don't press that point, other than to make the observation that
Yes. No. Thank you very much. I think I granted that application, didn't I? But thank you very much.
Indeed, my lord, and it's accepted that it was granted. But the point is that it was
Yes.
it was a
you don't want to
necessary
have to pay for
application, and precisely so. Yes, quite. But also subject to that, it's simply an exercise in proportionality. The proportionality, with due respect of a grade A solicitor attending today, whose costs are approaching that of counsel who represented the respondent, I say shouldn't be recoverable. That simply isn't proportionate or justifiable.
Right. Thank you very much.
Thank you.
Who is here?
My lord, I should just correct one matter. My instructing solicitors just checked, and literally just very recently, the rate has risen to 282 nationally.
Creeping ever closer.
I would only say that as was observed by Lord Justice Holroyde in granting permission, it's a matter of some importance, and,
yes,
and that was one of the grounds on which the appeal was permission to appeal was sought. My lord, I'm in your hands.
But in the end, it's not a question mark over the work done or the skill with which it was done. It's simply a question of whether the other side should have to pay so much for it.
My lord, indeed, and I'm in your lordship's hands.
Thank you both very much. We'll just rise and consider that issue. You will issue. Thank you. Jeremy, could you perhaps take this? no doubt descends. Yeah.
All right.
All right. I've got a bit of check.
Right.
Thank you. Mr. Crozier, we assess the respondent's costs in a global sum of £18,500, inclusive of VAT. So we order that the appellant pay that sum by way of costs.
Does your lordship wish me to have carriage of the order?
Yes, please. Thank you.
Then to have until 4 on Friday to file.
Yes, by all means. Yep.
I'm very grateful.
By all means, thank you. Well, thank you both. You've both been a great help. And Mr. Ward, although unsuccessful, if I may endorse what my lord said in giving the leading judgment, the submissions were well made.
Thank you very much, Mark.
Yes. Yes, Lord Justice Nugee suggests you email the draft order to his clerk. That's probably the most convenient way of dealing with it.
My lord, I will take the email address when your lordships rise.
Yes.
Get it from the JAs. Get it from the judicial assistants.
I will, my lord.
Good. Thank you. We wish you all a safe journey back west. No doubt the GWR will have benefited from the day.